Hello, everybody. Today we are going to go ahead and do our video here on the Marbury v.s. Madison Supreme Court case of 1803. I know I've kind of been pushing this for a little while now, but things, of course, come up in lives. So we're going to go ahead and finally hit this topic today. But really, this is just kind of taking a break from the president scale, but at the same time, I'm correlating it to relate to that because it involves the last president we discussed, and that was James Madison, although this was before he was ever president. This was when he was serving as Secretary of State under Thomas Jefferson. So today we're going to go ahead and cover this case, and this Supreme Court case is significant because it really is the first court case that really establishes the modern Supreme Court and the judicial system in a way, because it is the first time that the Supreme Court says that it has the power of judicial review, which judicial review is simply the power that the court has that we all know of today, that when you think of the Supreme Court, you know that the Supreme Court does have the constitutional authority that they can declare whether or not a law is constitutional. If it is unconstitutional, the court has every bit of right and power to strike down that law, be it on a state level or be it on a national level. So this is the case that really defines that precedent, because until 1803, this precedent was not really set in the Supreme Court's mind. It wasn't really something that was practiced, and it was something that was kind of new and controversial when it first came out, but today it has become probably one of the more cherished parts of the American governmental system and judicial process. So we're going to go ahead and start here. So we got to go back to the year of 1800. This was the election of 1800 when incumbent President John Adams was running against his vice president Thomas Jefferson of the Democratic Republican Party. And as we discussed in our Thomas Jefferson video, of course, Jefferson ended up winning that election after a very controversial and close election in 1800. Jefferson ended up being the winner, and he was inaugurated as the third president of the United States on March 4th of 1801. So on that day, Adams left office, and Jefferson then came into office as the third president. Now, between the time frame of the election in November of 1800 and March 4th of 1801, in that small little time frame that Adams still had in office, his lame duck days, as we would call them now, Adams tried to do certain things to try to ensure that his Federalist Party, of which he was a part of, would maintain some dominance in some area of the government. And he did this mostly because, A, the Federalists just lost the presidency because John Adams did not get reelected. And B, they kind of just lost their majorities in Congress. The Democratic Republicans under Jefferson just gained the majority, so it's becoming very much aligned against Federalist values because, as we all know, when the Democratic Republicans are in control, they're probably not going to pass anything that is pro-Federalist in nature. Kind of like you can compare to today, where thanks to the efforts of Donald Trump to act just like a complete and total idiot, he has gone ahead and given the Democrats not only control of the presidency, but he has also given them the drive to get in control of the other House of Congress that they did not already have in control. So thanks to Donald Trump, Democrats now have control. And as we all kind of know, it don't matter if it was the Democrats in control or the Republicans. If one of them was in complete control of the government, they would do anything to advance their own political agenda and not even really consider what the other party wants. This is what the Democrats will do now, and it's actually what the Republicans did at the very start of Trump's term and at the end of Obama's, because they were in control. So this is a conflict that's still playing out today in modern politics. It was playing out back then, and it has done so many times in American history. So Adams is looking for a way to ensure that his Federalist Party is not just some minority in the government. It has a voice, it has some kind of control or influence somewhere, at least the Federalist ideology and political views. And Adams finds a way to do this because in his final days in office, he and the Federalists in Congress go ahead and appoint several judges to the district courts, especially the new districts that had just been created, and there were about 16 or more that had just been created by Congress in the district courts of the nation. And Adams went ahead and, before, even in these last few months, when you might talk about the ethical dilemma of should we really be filling these seats when a new administration is coming in so soon? And Adams went ahead and filled them in anyway with Federalist appointees, people that kind of had the ideology of the Federalist Party and would conserve the Federalist mindset somewhere in the government because they would be heading many of the nation's courts. They would be acting as judges. Now, Adams and the Federalists did this to preserve that ideology, but this was not particularly looked upon very well by the Democratic Republicans led by Thomas Jefferson and James Madison. This was something kind of viewed as this was a cheap trick to try to ensure they had a place in power. And that's what it really was. Now, this happened, and of course this ticks Jefferson off. Well, Jefferson finds a way that he can do this to abstract these judges. And as they were termed, people were so outraged by them, and they were so last minute. Like some of these judges, as we'll go here, when you're appointed as a judge, you have to, before you can even take your seat on the court, before you can actually start your job, you have to receive your commission. A commission is just a formality paper basically saying, okay, you're checked over, okay, you can start. But you cannot start that judge job, your tenure on the court, until you have that in hand. And this applied back then as well. Now, these commissions were usually delivered by the office of the president through the Secretary of State. Now, Jefferson knew this. Now, in most cases, you might say, well, how is this a problem? Well, and Adams had done this at such a late minute. In fact, people called them the midnight judges because of how late they were in his presidency, that he had appointed these judges so late that although the federal government, Adams' presidency, was trying to get these commissions out to these newly appointed judges, they could not get the commissions out to all of those appointed judges before Adams left office. It was too many in such a short time frame, and we know how the mail system was back then. It would take days, weeks, even a month or so before you get anything. But Adams tries to appoint all these judges, but he runs out of time to fulfill and give all the commissions out, so that way these judges can actually take their seats on the court. And Jefferson comes into office on March 4th, and although some of the judges have received their commissions and have now been seated, there are a good handful who have not yet, and now Jefferson and his Secretary of State, James Madison, are the ones in charge of giving those Federalist appointees, the political opposite of their own party that they view as wrong. He is now in charge of giving them their official commission in order for them to start their jobs. Oh, Jefferson kind of knows he has these judges by the balls, so to put this. He knows he has them in a good position that they can't really do nothing. He can dictate what's going to happen with these judges, in a way. And Jefferson, of course, he's already angered. He doesn't view these judges as legitimate because it was such a late political trick by the Federalists and Adams to really appoint them. And thus, he's not too keen about having them be put on the court anyway. So he kind of tells his Secretary of State, James Madison, he tells him, I want you to withhold those commissions for the time being. I don't want you to give them out yet. But Jefferson fails to really give a reason why. And so does Madison. They say, oh, we're withholding your commission for the time being, but they really don't give any explanation as to why they were withholding that commission. So these judges, they don't have their commission. Well, big deal. Well, it is a big deal because without those commissions, those judges cannot take their seats on the court. They're not being able to do their jobs. Well, one of these judges that was still waiting on his commission was a Federalist from Maryland, and his name was William Marbury. Marbury was from Maryland. He had kind of been a Federalist politician in Maryland, and he had been appointed by Adams as a Federalist judge appointee to one of the newly created district courts. But he was still waiting on his commission because of this order from Jefferson to Madison telling him to withhold those commissions. So he couldn't start his job. Well, Marbury was growing as many of them were, he was quite upset at this because he realized what Jefferson was doing. He was intentionally stalling them from taking their positions. But there was really nothing in the Constitution that dictated that Jefferson could really revoke the commissions, but there was nothing in there that said he could not withhold them for some reason, but he really didn't give a reason. Marbury grows so upset with this that he takes this and petitions the Supreme Court of the United States, and he petitions them to issue a writ of mandamus that would force Secretary of State James Madison to hand over those commissions, including Marbury's, to him, that would hand Marbury his commission, or he must give Marbury a reason of evidence as to why he couldn't do it. And it had to be something other than the president's word. It had to be a legitimate reason as to why can you not give me my commission? Is there a problem? Is there a serious threat? Is there a malfunction here or what? If you can't say there is, by law, I'm supposed to get my commission. So I want it. And I'm going to get a court order telling you have to. Basically, that's what a writ of mandamus is. It's just the court. It's the court ordering somebody that you must do this or else. So Marbury petitions the Supreme Court. He doesn't even go for the other courts. He just automatically goes to the Supreme. Now, eventually, the Supreme Court takes up the case. They don't take it on immediately upon Marbury's commission. They actually wait about 2 years before they actually take up the case. So by then, it's kind of been downplayed in the public eye because the tenureship that Marbury would have had he started his judgeship on time would have been almost over at that point. So even if Marbury got his commission, he wouldn't have been able to be a judge for very long. And most people just kind of viewed it as a fleeting little argument that it wasn't really going to gain anything for him, and they didn't really understand why it was even being pressed, so they really didn't pay that much attention to it. So 2 years after Marbury petitions the Supreme Court to take up and issue a writ of mandamus, the Supreme Court finally takes up the case as to asking whether or not they will issue this. So they have a court trial to determine, are we going to issue one? The Supreme Court at that moment is under the Chief Justiceship of John Marshall, our fourth Supreme Court Justice, and he was actually one of the midnight judges himself that was appointed by John Adams on his way out. So in a way, he was a Federalist himself and should ideally have ideologically, I don't know if I'm saying that right, agreed with Marbury because they have the same political belief. So John Marshall, who is a Federalist at heart, is on the Supreme Court, and he's the Chief Justice. So this doesn't look exactly promising for the Democratic Republicans. Well, they start the court case in 1803. Now, Madison, at the court trial, he argues that the actual signing and sealing of the commission that was given to him by the president, that was what completed the transaction of Marbury being able to take his job. There was nothing after that. As soon as the commission was signed, he could take his job. He said that the delivery of that commission to the judge, to the appointee, was only a formality. You didn't have to have that commission delivered to you in order to take your seat on the court. Now, Madison and Jefferson both knew this was a load of crap because, honestly, the Constitution even states they have to get their commission. They were simply trying to come up with a dumb excuse. And in reality, knowing that, they argued that you didn't have to have it to start your tenureship on the court, but they knew that you did. They just wanted to say, oh, no, you don't need it. Make him look stupid. When in reality, if you really look at it, it's not that easy to point out that the Constitution does kind of state that the judges must have their commission in hand. So Madison argues that he doesn't have to deliver it. It's only a formality, so he really don't need to. It was already confirmed by the official signing of it by the president. Well, Marshall, who is himself a Federalist, as we declare, eventually is the one that makes the main decision. He's the main decider in this court case. And this was actually his first court case that he presided over as Chief Justice. He had just been appointed 2 years earlier, and he would be on the court as its Chief Justice until his death in 1835. So Marshall is going to be the main person that comes to conclusion here of what we're going to do with this court case. will Marbury get his job, and does he have a right to the commission that Jefferson and Madison have kind of withheld from him? Marshall determines first, he comes to three determinations. The first determination that he comes to is that Marbury had a right to receive his commission. He did have a right to get that commission handed to him. There was no constitutional privilege, there was no constitutional authority that gave Jefferson and Madison the right to refuse him that commission. So Marshall, on the first argument, he rules in Marbury's favor. Yes, you do have a right to your commission. They cannot withhold that from you. Second, Marshall also agrees with Marbury that he does have a right to remedy or to have a solution done to appease this problem, this insult to him, to right the wrong, so to speak. He does have a right to remedy this, to have it be corrected. The last question that Marshall really comes to an answer to is the most crucial in the court case, and it's what comes and kind of dictates the outcome. Now, keep in mind, Marshall is a Federalist. He's more inclined to agree with Marbury than he is Jefferson, and in fact, in his notes in public life, Marshall was sometimes a very big critic of Jefferson, because he was on the Democratic Republicans, which was the opposite political spectrum. And Marshall so far has ruled in favor of Marbury, in favor of him being able to get that commission and being able to have it be corrected so that he can take his job. But the last question is simple. Marbury had asked that the court issue a writ of mandamus, basically a court order saying that they have to give him that commission. So Marshall asked himself and the court a simple question. Would the proper solution to this problem be a writ of mandamus from the court? So he ponders this, and eventually Marshall comes out with the big ruling that defines this court case. Marshall eventually rules on the court itself. Now, this might seem odd. You're like, well, this is supposed to be in judging. This is supposed to be judging two people, not the court. And yes, you would be correct by that. But Marshall turned this around as he saw this as an opportunity to stake out a claim for power in the federal government that the Supreme Court would have. And he goes ahead and has the court rule on itself, and Marshall rules that although Marbury had a right to his commission, and he had a right to remedy, to have that wrong righted, the court had no right to issue a writ of mandamus in the case. Now, Marshall ruled this way, saying that the court has no authority to be issuing a court order to demand this, because he rules that by stating that Section 13 of the Judiciary Act of 1789 was unconstitutional. And this was an act passed in 1789 at the very beginning of the federal government when George Washington had just took the oath of office and was in his first year as president. And the act had given the court original jurisdiction in an area where the Constitution said it shouldn't. Now, the Constitution, they were different. Now, you might ask, well, what is original jurisdiction? Original jurisdiction is referring to a court will gather its own evidence and then will hear that evidence. It does its own investigation into a case and then hears what the defense or the prosecutors have to say. So, the Supreme Court does its own investigation into the matter. In an appellate case, it hears and passes judgment on a case that has already been presented, and it's simply reviewing that case. It's not really passing a judgmental trial, it's simply reviewing that case. It's not upholding, it's either upholding the judgment of that court, of a lower court, or it's saying that maybe that court needs to look at it again, really. But original jurisdiction is like typical court trial that you would imagine. And Marshall rules that Section 13 of the Judiciary Act was unconstitutional because it had given the court original jurisdiction in an area where the Constitution said that it should not. And Marshall ruled that this violated Article 3 of Section 2 of the U.S. Constitution, and thus the act was unconstitutional as it did not follow what the Constitution stated was legal. Hey, I do apologize for the little pause there. I had to go run and get a copy of the Constitution here. So if you noticed a small glitch, that was what that was. I had to pause the video. But anyway, as we mentioned, Marshall basically ruled that the Supreme Court could not issue the writ of mandamus to Marbury because of, to put this in simple terms, the court could not issue said writ because the law that allowed the court to issue it was unconstitutional itself. And thus, the court really did not have the jurisdiction even with that law. And Marshall said this violated Article 3, Section 2 of the Constitution. Now, refresher, the Judicial Act of 1789 had given the court original jurisdiction, the ability to gather its own evidence and have its own trial, in an area where the Constitution said it shouldn't, basically in the case of a judge. Well, if we go to the Constitution, and we go to Article 3, which is discusses and kind of creates the judicial branch. Article 3, I'm going through the amendments. Article 4, here's 3, and we go to Section 2, right here. You can read any of that. But we're going to go to Section 2. Yeah, Section 2 starts right up here. And according to the Constitution, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. But Marshall argued that because the Constitution stated in Section 3, Article 3, Section 2, that I quote, the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers, and consuls, and in those cases in which a state shall be a party. None of those talk about court judge appointments. None of that. Those are not considered to be public ministers. So they don't fit into that original jurisdiction category. And the 1789, which dictated, oh yeah, you can do that. Well, the Constitution says I can't. So that's unconstitutional. And Marshall rules on that. And he says, although I agree, you have a right to your commission. You have a right to have a remedy. We do not, as a court, have any authority to give you this remedy because we have no authority to really issue this writ in this kind of case. Because in honesty, we shouldn't even be hearing this case. So Marshall, ultimately, it goes to Jefferson and Madison's favor by, although he's agreed with Marbury to this point, he does recognize the court really doesn't have any power to make Madison and Jefferson give him that commission because they have no court right to even be issuing anything or even be trying a case in this matter. This case should be appellate jurisdiction, not original, and thus it shouldn't even be tried in the Supreme Court. So ultimately, Marbury does not get his commission in time. He eventually gives up. And this ends the case. But this is what really, although it seemed that the court ruled in Jefferson and Madison's favor, Marshall did this to stake out a claim of power for the Supreme Court and the judicial system. Up to this point, the main balance of power was struggling between the legislative, Congress, and the executive, the president, and their balance of power over who could do what as a checks and balance system. But the Supreme Court and the judicial system had kind of stepped and just kind of stayed on the side. Now Marshall's staking out a claim saying that Marshall further ruled that the court has the power of judicial review, meaning the court could review in the authority of any law that the president or Congress, the executive and legislative, the court had the right to review any law or order passed by those two branches of government, and they could rule on whether or not those laws or orders were considered constitutional under the U.S. Constitution. Basically, it gave the court authority that if a law was found to be unconstitutional by the court could strike that law down. It cancel it. Just nullify the thing out of right. And this sets out the process of judicial review. The judicial review principle, the court has the right to judge whether or not a law or order is considered to be constitutional or unconstitutional, and if it is unconstitutional, the court has the right to nullify and cancel that. So this is what the importance is of Marbury versus Madison. Although Marbury was the main person that brought this, although it was originally about a guy getting his commission for a judgeship, it eventually turned into the court ruling on its own power and establishing a very important democratic principle that the court could decide if something violated the Constitution or not. So this gave the court power. So that is the gist of why Marbury versus Madison is so important. It establishes this very important democratic principle that is still highly regarded and still widely used today. It's something that we look at now like nothing, but back then that was an entirely new concept. And I can tell you this with certainty that when Marshall ruled on this with the rest of the Supreme Court justices, Congress was not too keen on having the factor known that if they passed a law that was unconstitutional, the court now could strike that down. So, of course, the president was probably worried a little bit as well, but it was mostly Congress who was going to be scared because they're the ones usually making the laws. So that is the gist of the Marbury versus Madison court case. Now, as a reminder, we had two. Right here was James Madison, our fourth president. He was just Secretary of State at the time. He was not president yet, but this is him. He was the defendant in the case, as he was with Thomas Jefferson in denying Marbury his commission. And then right here we have a image of a painting of Chief Justice John Marshall, who was the main justice during the Supreme Court case. This was actually the first major one that his court heard, and he was the one that made the very important and pivotal ruling in Marbury versus Madison. He would continue to be the Supreme Court justice until 1835. Which, in a way, you could consider that since he was a Federalist and the Federalist Party died out about the 1824, and he was still the Supreme Court justice, Chief Justice of the Supreme Court until 1835, Adams had somewhat succeeded in maintaining a Federalist influence somewhere in the government for a while because Marshall was there. And even after the Federalists had lost power and kind of dissolved, Marshall was still in the Supreme Court and was upholding some of their philosophies in his judgment. So that concludes today for our Marbury versus Madison video. Now, for the next one, I think I want to hit something with the international theme. I'm thinking of the Battle of Hastings, not Battle of Hastings, but the Norman Conquest of England in 1066. I'm not entirely certain, but I do want to do something with international history next. And then on February 8th, if it works out right, sometime during that week, we will have a video on a historical anniversary that is occurring this year, as this year marks 160 years since the start of the American Civil War. And it was on February 8th of 1861 that the seceded southern states came together. At that time, it was just 7. And that was the date they came together and officially created and formed the Confederate States of America. Not exactly the best chapter in American history, and believe me, I'm not going to discuss the issue to try to promote white supremacy or anything like that, because that is wrong. What we're going to look at in that video is I'm going to simply look at, from a historical viewpoint, what brought the crisis to that head, that the southern states decided they were going to not only secede, but they were going to form their own nation, and what was their justification for doing so. And in that, we will talk about slavery, and I hate to tell you people, and we're probably going to have another video related to the Civil War, and I want to discuss the lost cause narrative that has been developed after the Civil War, where a bunch of these pro-Southern, pro-Confederate people over generations, even today, they have kind of maintained that the Civil War was never about slavery. It was about states' rights. It was about every other excuse in the book. I hate to tell you people, it was about slavery. Either you want to admit it or not. One way or another, the circle comes back around to that issue. So, I don't know what story narrative that these people try to tell themselves so they can sleep at night, but it's sick and it's disgusting that they would ever consider that conflict was not in any way perpetrated by slavery. So for certain, our next video, I'm looking at the Norman conquest of England, but we'll look at what that is. It will definitely be international history, world history. And then we will go to get the founding and kind of ideology of the secessionist crisis in the United States in late 1860, early 1861, leading up to the formation of the Confederate States. And then I'll probably have the Lost Cause video either right after that, or we will have one, or we might wait, do our 5th president next, James Monroe, after the February 8th video. Yeah, so here's what we're going to do. We're going to do that. We'll do the Norman conquest of England. Then we'll do one on the formation of the Confederacy. Then we will do one on the 5th president of the United States, James Monroe, and then we'll hit the Lost Cause narrative and kind of discuss why that is so misguided and how that even came about. So that is 4 videos that we're going to plan for next to kind of discuss here. So that is what we got to look forward to. So I will hopefully I might even get to the international one at the end, the world history one at the end of the week. So we'll see. It will definitely be up by next week. So have a good rest of your week. If we do not see you back by the end of the week, then definitely we'll see you next week. So, as always, like, subscribe, comments, suggestions, as usual. So, that concludes for today's video. So, have a good rest of your week, and may God bless you all.